I want to thank you very much for the opportunity to present SB 54, which will protect the safety and well-being of all Californians by ensuring that state and local resources are not used to separate families and ultimately hurt the California economy. This past week, the President confirmed some of our worst fears by signing an executive order on interior immigration enforcement. He will not focus on criminals, as he promised on the campaign trail. Instead, his deportation policy will be a dragnet for thousands, if not millions, of hardworking immigrants. This past week, the President confirmed some of our worst fears by signing an executive order on interior immigration enforcement. He will not focus on criminals, as he promised on the campaign trail. Instead, his deportation policy will be a dragnet for thousands, if not millions, of hardworking immigrants. The executive order dramatically blurs the definition of what a serious criminal actually is. Senate Bill 54 does three things. One, it requires state agencies to review and update their confidentiality policies so that Californians are not deterred from seeking services. Two, it requires public schools, public health facilities, and courthouses to remain safe and accessible to all California residents, regardless of immigration status, by limiting immigration enforcement on their premises. And lastly, it prohibits the use of state and local resources to aid in immigration enforcement. No state or local law enforcement agency will detain or transfer a person for deportation unless there is a judicial warrant. It is incumbent on us to put the proper policies in place so that police and other local agencies can focus on their chief responsibility, protecting Californians, not acting as federal immigration agents. Let me be very clear. This measure does not impede the enforcement of federal immigration law. It simply restricts the commandeering of our resources and tax dollars to do the job of the federal government.
Plausibly live from the Podcast 99 studios, located in beautiful downtown Manteca, California, this is the Dave Bowman Show. Now, here is your host, the submarine qualified, coffee-swilling, stuffy elitist history buff, Dave
Hey, welcome
Bowman.
aboard, cheese lovers. It's me, Dave. Glad to be with you today. It's a busy day, as you may have heard already. We've got a lot of stuff going on today, so I'll try to get through this, get on my way. Eloqui conitio. Stand up. Tell those who oppose liberty, don't tread on me. So as you heard at the beginning, and perhaps if you've been paying attention to the news, you've heard this already, the state of California has decided that it is going to become a sanctuary state. Now, you may be saying to yourself, that David hasn't done that yet. We have a two-thirds majority Democrat state legislature, Democratic governor, who have made it very clear that they favor illegal immigrant rights. And so I'm just going to go ahead and call it now. It's a foregone conclusion. Now, the typical conservative response to this is to flap our arms, yell and scream, get right into the microphone and yell a lot about how ridiculous this is, how out of control this is, and how absurd this is. And no doubt you've heard plenty of that. The president himself has said California's out of control, threatening to cut off funding, all those kinds of things. But I think this is one of those cases where if we sit back and we take a dispassionate look at things, we might come to different conclusions. And ultimately, we might start thinking. And of course, that's what neither side wants us to do, so on we go to the thought process. California wants to become a sanctuary state, and as you heard there, that is Senator Ghost Gun DeLeon introducing what is now known as SB 54 into the state legislature last week, where he describes it as essentially doing three things. One, updating confidentiality agreements and policies. Number two, making sure that schools are, which by the way receive federal funding, are safe zones for illegal immigrants. And lastly, making sure that no state resources are spent enforcing the executive order, the policies of the president as far as immigration go. And I think it's here that we find we're going to be surprised a little bit as to what really things are. Now, the whole country is based on the idea of federalism. You have the federal government, you have the state governments, and they share power except where it's specifically delineated that the federal government is responsible for something. The federal government, of course, is by definition responsible for immigration. We've seen this before. A couple of years ago, Arizona passed its law regarding illegal immigrants and the likes of that. They were slapped down quite hard by the Supreme Court and by the administration and by virtually everybody left of center in the entire country as overstepping their bounds and being out of, this isn't your place to do this. Of course, now that it's happening in California with a Republican president, we get the opposite approach. We get protests nationwide. We get discussions about why this is the best thing to do and how California is leading again. So who's right? I mean, where is that line in all of this? And when you start dealing with social issues, and when you start dealing with federalism in the face of social issues, you start seeing that the history of this country is one of push, pull, give, take, back and forth. Of course, the primary issue being slavery, but there were others as well. In the late 1790s, you had the Alien and Sedition Acts that John and I have talked about at great length. And you had states like Kentucky, which was a relatively new state, Virginia, come up with their nullification ideas and the fact that they believed that they could nullify any law that they believed was unconstitutional. Now, this, of course, was a radical thought process at the time, but most importantly, what it did was it applied social pressure to Congress and to the nation as a whole. Congress never buckled on it. Congress and the Federalist Party, they never buckled on it, but the nation did. And the nation elected another party, and that other party refused to abide by the Alien and Sedition Act, which then retired. You had the states' rights doctrines of 1815, in which the states really put forward their ideas that we have powers here that the federal government should not be interfering with. And it's interesting because I often say states' rights, and whenever I say states' rights, what I'm referring to is slavery. But this was a case where they weren't talking about that. And we don't have time to get into the whole details of it, but you need to understand it was an issue in 1815. And then in 1842, an event happened which I think reverberates today. And in fact, as we look at California wanting to become a sanctuary state and the social political issues of this is, as far as I can find, still the law of the land. Now, the ruling is, not the law itself, but we'll paint the picture for you. As you know, when the Constitution was ratified, when it was debated, when it was written, when it was ratified, slavery was the sticking issue. And there were parts put into the Constitution that did not specifically state slavery. They never used that word. But it was clear that that's what they were talking about. And one of those areas was the fact that the South wanted ways, legal ways, protected to get slaves who escaped back. Whatever you think of that today, and who doesn't, this was something that they argued about very strenuously, and they won on that point. Later on in 1793, Congress passed the Fugitive Slave Act, which allowed legally people who were essentially bounty hunters to go into free states, find slaves that had escaped, and arrest them and return them to their owners or return them to the states where they came from to be resold. Inevitably, you know what happened. Inevitably, a woman who was a slave, technically, she was owned, in the state of Maryland, which was a slave state, had lived her entire life as a slave, but it would be hard to describe her life as one in slavery. She was essentially free. She lived her life the way she wanted to, and one day she decided that she wanted to move somewhere else, and so she picked up and moved to Pennsylvania, which of course was a free state. Into the state came, sometime later, a man by the name of Prigg, who was one of these agents, these bounty hunters, who found her, arrested her 4 children, including one who was freeborn in Pennsylvania, hauled them back to Maryland, and because the owner had passed away, the rather benevolent owner who had allowed her to live her life as she wanted, the children had wanted her back because it was part of the estate, and that's what had caused all this ruckus. Brought her back. They didn't really want her, but they wanted the money, so they had her sold, and the 4 children as well. Now again, I realize this is repulsive to us. I get that. Stay with me here. The person was sold off. Pennsylvania, however, in the meantime, had passed a law that, because of its virulent abolitionist attitudes, essentially said that anyone who used force, violence, in the apprehension of any person, is the way their law said it, but it meant slaves, and took them across the state lines, would be charged with a felony in the state of Pennsylvania. So, of course, they had Mr. Prigg extradited back to Pennsylvania, where they charged him with essentially what we would call today, kidnapping and across state lines. So it would be a federal offense now, but in that era it wasn't. Mr. Prigg was convicted under Pennsylvania law and appealed, as you can guess he would, because of the federal law, 1793 Fugitive Slave Act, and because of the Constitution. The argument was that the Pennsylvania law was unconstitutional because it essentially overrode the Constitution's 2 paragraphs about returning property, and it overrode the 1793 Fugitive Slave Act. This went all the way to the Supreme Court of the United States, where, in one of the more unique judgments, the court all agreed that the Pennsylvania law was unconstitutional. All 6 judges agreed, but all 6 judges wrote their own opinions. Their reasonings for doing so were clear. The law does violate the Constitution, which said very clearly property must be returned. This was part of the negotiation. It was part of the issue. And it would create other issues as well downstream from this. But importantly, one justice by the name of Story made it clear in his opinion. He used the phrase, if I can read it here, unless prohibited by state legislatures. He was referring to the fact that Pennsylvania had a duty to uphold federal law, meaning that its officers, its law enforcement officials, its public servants had a duty. They swore to uphold the Constitution of the United States and of the state of Pennsylvania against all enemies, foreign and domestic, just like we do today. And consequently, they had a duty to do so, to uphold those laws, unless, as Story wrote, prohibited by state law. And of course, state law in Pennsylvania did not prohibit them from doing so. Do you follow where I'm going here? Do you see it already? Prigg's conviction was overturned by the Supreme Court. He was let go. This led to all kinds of brouhaha in the country in the 1830s and 1840s, as you're well aware. In essence, this ruling helped lead to the Compromise of 1850, which essentially admitted California into the country as a free state, but the trade-off for that was that the North agreed that they would enforce the Fugitive Slave Act, unless, as Story wrote, prohibited by state law. But part of the agreement was, even though the states in the North, particularly Pennsylvania and others, began passing what they called personal liberty laws, to say, well, you don't help them. If a bounty hunter comes into our state, a slave hunter comes into our state, you are now forbidden from helping them. We will not use state resources to do so. Does this sound familiar to anybody? Okay. The bounty hunters can still come in. They can still do their thing. We won't help them. We will not support them. We will not tell them where to go. We don't give them maps. Nothing. We will do nothing for them. This, like I said, led to the Compromise of 1850, which was California plus enforcement of the Fugitive Slave Law, so forth and so on. Now, what you need to understand about this is this ruling, Prigg versus Pennsylvania, for all practical purposes, has never been overturned. The position of the court, based on precedent, is that unless a state official is prohibited by law from enforcing federal law, federal policies, he has to do it. He or she has to do it. But if the state says, thou shalt not, then the official, theoretically at least, is covered and doesn't have to do that. And a state can refuse to do this. Now, this is an important idea here because, again, what we're into is social policy of the nation as affecting national policy. Now, think about all the times in our history where the social impact of positions in the country affected national policy or differed from national policy, and one or the other was going to win. You have, of course, the biggest example of all, the Civil War, where you have 11 states that very much favored slavery and a number that didn't, a federal government that didn't, and they attempted to force the federal government to see it their way, and they lost. Following that, you had an era of what I would call the pre-Jim Crow laws. These were laws that were not, we tend to think of the Jim Crow South in the 40s and 50s and 30s and 40s and 50s, but this was prior to that. This was in the 1860s, prior to the 14th Amendment. So this would be the due process idea, the idea that the states would have to abide. The states began to resist the federal laws, the abolishment of slavery, the right to vote. They began to resist that by their again, personal liberty laws, which were then overturned by the Due Process Clause of the 14th Amendment. You had new nationalism in 1910. This was started by Teddy Roosevelt, this idea that and this is an idea that deserves so much more in-depth consideration. When I get time, this is one of those things I want to sit down with Josh Carter and talk about, and Bryce, and talk about over on the Resistance podcast. Roosevelt, Teddy, essentially believed and taught, and his policy was that the executive, the president, was what's the word he used? Steward. The steward of the public's trust. In other words, that it was the president and no longer the Congress that acted on the will of the people. And so he saw himself as the stalwart of the people, and he began to build the power of the presidency in that mentality. And if you think about it, a lot of it had to do with that. You had the 16th Amendment come along in 1916, and we've talked at great length about prohibition, but prohibition never happens without the 16th Amendment. And so you had this social movement for abstinence, for doing away with the abstinence. Is that the right word? Temperance. Sorry, not abstinence, temperance. Abstinence wouldn't work. But temperance, you had this social movement. But the temperance folks understood that the government made its money on liquor. And so if people would start paying taxes, then the government would need liquor. And so we could do away with that. And so you had this social movement that pushed into the taxes. In 1933 to 1938, you had the New Deal, which kind of became, as one historian describes it, the fault line between how Americans felt about government before and how they felt after. Before the New Deal, most Americans, despite people like Teddy Roosevelt and Woodrow Wilson, most people considered government, the federal government particularly, to be a threat to liberty. After the New Deal, people began to see government as their protector, their provider, in many ways, their salvation, if you will. And it's kind of that fault line. In 1954, you had Brown versus Board of Education, which helped develop some other doctrines about how far the government can go. And this is where California is going to run into problems here with what DeLeon had to say. And number two, which is, of course, this doctrine of interposition, where we control the schools. No, we pay for the money. We give you the money, so we get to control your schools. Well, DeLeon can say that. He can say, well, the schools are going to be safe zones, but where do the schools get their money? For the most part, where do the schools get their money? And so if you apply the golden rule, he who has the gold makes the rules, you can kind of see some problem there. But it's that third area where I think we're going to see some headbutting, reminiscent of what we saw in the 1830s and 1840s, all the way up to the Compromise of 1850. And that is, what essentially SB 54 has become is what was known then as a personal liberty law. It is a law which permits California officials, elected and appointed, it forbids them to uphold a federal law. As Justice Story wrote, unless prohibited by state law. They have to do this unless prohibited. Well, if SB 54 passes, and presumably it will, and go into effect, our state officials would be prohibited from enforcing some federal laws, particularly with regards to immigration. And therefore, it would be up to the feds to enforce these laws. Now, again, what you need to understand is this decision has not been, as far as I can find, has not been reversed. So this is still precedent in our country today that states can pass personal liberty laws. Now, the personal liberty laws of the 1830s and 1840s went away because of the Compromise of 1850, which, again, admitted California as a state into the Union, but required the feds, or the states that were resisting federal policies, to enforce those federal laws. Which brings us to the real question here. What exactly is California trying to accomplish here? And what's the end game for all of this? What happens if California's SB 54 goes into effect? Do we get a tit-for-tat game where the federal government says, okay, you get no money for schools, check, no money for this, check, no money for that, check, until you agree to do this. And California's infrastructure, of course, which is based heavily on federal dollars, essentially falls apart. Is that good for the state of California? Is that good for the country? Those are questions we need to ask. Because again, as conservatives, are we putting the nation's good first? Or are we putting ourselves first? Now, I ask that question because, again, I don't really care where you live. If you live in California, I don't care if you live anywhere. If you live anywhere in the Union, in the United States, you need to understand that the reason your food is affordable is because of the way we do farm labor in this country, not just in California, but in the country as a whole. And consequently, you have a situation here where if we force California to enforce those rules, and by extension other states to do so as well, what happens to the well-being of the entire country? What happens to your food prices? What happens to construction prices? What happens in the overall situation? Now, again, I'm not saying right, wrong, or indifferent here. What I'm asking is, are we considering all the permutations of this, all the variables in this? And is this really the hill that we want to die on as conservatives? Now, on the other hand, as liberals, progressives, as the Democrat Party ruling California, is this really the best way to go around this? Is it really that important that we go beyond where we are? In other words, for the past, let's say 20 years, I guess, are we really in a position where people have been knocking down doors at farms to haul off farm workers? I mean, it happens on occasion, but usually it's a very egregious violation of something. But on an average day-to-day basis, is there anybody that doesn't know that most of the people picking fruit and vegetables in the fields aren't illegal aliens? And does it really bother you that much? But when we start pushing to, in essence, give them things, support them, as the fault line begins. When our state government becomes the lifeline for the illegal immigrant, is that really the best way to go about that? And is this really the showdown that we want? Because what ends up happening, who wins this in the end, is what I'm really kind of worried about. Because ultimately what's going to happen is the court is going to make a decision. Right now it's 4-4, but by the time SB 54 gets to the Supreme Court of the United States, and my guess is that it eventually will, it will probably be back to 4-4-1 again. You have to wonder at this point, would the court look at that and go, well, federal law, Supremacy Clause, going all the way back to pre-constitutional eras. This is what Hamilton was arguing about in the Federalist Papers, and when he argued in front of the New York Mayor Court about some loyalists. This argument, this states versus federal, is the same argument we've been having since 1775, 1776. It really is. And each time it ends with a compromise of some kind that leaves one side or the other either beaten or, with a worse scenario, kicked down the street. What's the ultimate solution here? I mean, what's the compromise that California ends up accepting to enforce federal immigration laws that the Fed would accept? And again, I personally don't believe that the federal government wants every illegal immigrant in the California fields booted out of here. If they do believe that, and again, I don't believe that they do, but if they do believe that, they're insane. If you believe that, you're nuts. But how far are we willing to go for them when we're giving free education, free college, free medical? I mean, how much stuff do we have to give them in order to make this compromise work becomes the question. And where is that line? How far are we willing to go with this in order to, in essence, reach our compromise with the federal government and the state of California so that the federal government isn't cutting off education funding and the local law enforcement isn't losing its money, like Scott Jones up in Sacramento says, because we need it to prevent crimes. And at what point does the nation say, okay, well, does California acknowledge the fact that there are violent illegal immigrants who are committing horrible crimes, and it looks bad on the entire bunch. And rather than cracking down hard on that, they're essentially coddling it. They're essentially welcoming it in, much as Pennsylvania did in 1834. Where is that line, I guess, is the question. Where should it be? What should we be willing to compromise on, knowing that personal liberty laws do exist, that the court has said, in essence, that, at least in my view, parts of SB 54 are perfectly legitimate. In fact, they're doing exactly what the Supreme Court said to do back in, 1840, 42. But at the same time, knowing that what it took to get past that eventually led to a civil war. How far are we willing to take this, California? How far are we willing to push this? How far are we willing to say, sure, we have personal liberty and we don't have to help you, but it might be in our best interest to do it. And the Fed side of this is how much are they really trying to crack down on this versus how much is this is just posturing, and how far are they willing to go before they stand up and go, okay, maybe we don't need that much. And it's at that point maybe that I think we can sit down and work all this out. But in the meantime, I think California has a case. I think 1 and 2 are going to lose. What he said, the confidentiality agreements in the school grid, they're going to lose. But number 3, that's right out of our history. Prigg versus Pennsylvania, 1842. What do you think? Dave at thedavebowmanshow.com or 565-DAVE in the 209 area code. Take the time right now. Tell the people that matter in your life you love them very much. You'd miss them if they weren't there, so don't pass up those opportunities. You don't want to have that regret. Plausibly Live, I am Dave Bowman, and this is the Dave Bowman Show on podcast.
The Dave Bowman Show is a Slippery Fish Entertainment production for the Podcast 99 Network. Copyright 2017. All rights reserved. For more information or to contact the show, log on to www.thedavebowmanshow.com.
Hey, I'm gonna go do something productive. I'm gonna go watch television.